Hello friends, very warm welcome to my business laws channel. Till now friends, in my previous videos, I have covered chapters up to 6 under the Indian Contract Act 1872. So today friends, in this video, I am going to begin chapter number 7. Chapter number 7 is void agreements. You all know friends, one of the essentials of valid contract as per section 10 is that agreement should not have been declared expressly void under the law. So friends, there are certain void agreements. There are certain agreements which have been declared as void under the law. And these agreements are first is agreements in restraint of marriage as per section 26. Second is agreements in restraint of trade, section 27. Next is agreements in restraint of legal proceedings, section is 28. Then agreements, the meaning of which is uncertain, section is 29. Agreements by way of wager, section is 30. Agreements contingent on impossible events, section is 36. Agreements to do impossible acts, section is 56. So friends, in my today's lecture class, I'm going to take a very important 2 questions. The first one is agreements in restraint of trade as per section 27. And second point which I will take up, that is agreements by way of wager. These 2 questions are very, very important from examination point of view. The question which is asked in the examination, agreements in restraint of trade are void. State the exceptions to this rule. Very, very important question. And second question is, define the term wagering agreements. What are the various provisions relating to wagering agreements, and distinguish between wagering agreement and contract of insurance. So friends, I will cover these headings in today's lecture class. Agreements in restraint of trade as per section 27. So what is this agreement? Agreements in restraint of trade. Every agreement by which any person is restrained from exercising a lawful profession, trade or business of any kind is to that extent void. This liberty is guaranteed by Article 19 of the Constitution as a fundamental right. Public policy requires that every man shall be at liberty to work for himself and shall not be at liberty to deprive himself of the fruits of the labor, skill or talent by any contract that he enters into. So friends, all agreements which are made in restraint of trade are void. Now, when we talk about these restraints of trade may be partial or total, general or particular, whether qualified or unqualified. Qualified means conditional. Unqualified means no condition is attached. Partial is partly. The constraint is partly. And total is, all constraints have been laid down. Total constraints, full constraints. So whatever constraints are there, all are void in India. Whereas under English law, only absolute or total restraints of the trade are void. It's a very important case law before you, which is Madhov Chandar versus Raj Kumar. A and B were carrying on similar business in the same locality in Kolkata. They entered into an agreement whereby A agreed to close his business in Kolkata in consideration of B paying a certain sum of money. A accordingly closed his business, but B refused to pay the amount promised. So consequently, A filed a suit for the recovery of the amount. This agreement was void. 2 parties cannot enter into such agreement that if you have to close down this business, I'll pay you this much money. So this was held as void in the court of law. No, but there are exceptional cases where this rule is not applicable. That is, the agreement restraining trade is not void, it is valid. So friends, these restrictions we can put under two categories. First is statutory exceptions or restrictions, and second is judicial exceptions. There are certain exceptions which arise from judicial interpretation of Section 27. And both the exceptions I will take up, friends. First of all, I'll talk about statutory exceptions. One statutory exception, sale of goodwill, provided under Section 27, and other statutory exceptions have been laid down under the Partnership Act 1932. So the very first point is, friends, sale of goodwill. According to Section 27, the seller of the goodwill of a business can be restrained from carrying on a similar business within specified local limits, so far as the buyer or any person deriving title to the goodwill from him carries on a like business thereon, provided the restraint is reasonable in the point of time and space. So friends, there is a case law regarding this, which is Gold Sol versus Goldman. So friends, once the goodwill of the business is sold, then seller of the business is not allowed to carry on the similar business. And if he carries on, he violates these provisions, then in that case, the buyer of the business has the right to file a suit against him. The facts of this case law are: A seller of imitation jewelry in London sells his business to B and promises not to carry on the business for a period of 2 years. First, in imitation jewelry in England, B is in real jewelry in England, C is in real and imitation jewelry in certain foreign countries. So it was held in the court of law. First restraint was valid, but second was not valid because, second was regarding real jewelry. Here the business was regarding imitation jewelry. And the third restriction laid down was in real and imitation jewelry in certain foreign countries. So here, friends, these restrictions are not reasonable. So restrictions should be reasonable only they are valid. So in this given case law, only the first restriction was valid. Now coming to the second point, under statutory exceptions, which is exceptions under the Indian Partnership Act 1932. First is agreement with the continuing partner. An agreement among the partner that a partner shall not carry on any business other than that of the firm when he continues to be a partner. This restriction is there, but it is not void, it is valid. Second is agreement with the outgoing partner. An agreement between a retiring partner and the continuing partners that a retiring partner on his retirement from the partnership firm shall not carry on any business similar to that of the firm within a specified period or within local limits. So friends, remember, these constraints should be reasonable. If restriction is not reasonable, then in that case, that will not be valid, that will be void. And third point is agreement among partners upon dissolution of the firm. An agreement among the partners that upon dissolution of the firm, some or all of them will not carry on a similar business to that of the firm within a specified period or within local limits. So provided the restriction imposed are reasonable. So every time, friends, you will have to bear in mind that restrictions must be reasonable. Then only it is valid. If we talk about unreasonable restrictions or for throughout his life or anywhere in the world, then these restrictions seem to be unreasonable. So therefore, these will not be valid. Then agreement in case of sale of goodwill of the firm. An agreement between any partner and the buyer of the firm's goodwill. Once the goodwill of the business is sold, in case of partnership firm, then also the partnership firm partner, they are not allowed to carry on the similar business within specified period or within specified local limits. And now, friends, I'll talk about judicial interpretations. First point here is trade combinations, where the primary objective of trade combination is to regulate business, not to restrain it. Because many times, trade combinations, they decide that goods will not be sold below this price. So friends, here restriction is there, but this restriction is not void, it is valid. But a combination which tends to create monopoly and which is against the public interest is void. Similarly, agreement is also void where two firms enter into the agreement to avoid competition. Now, friends, I hope you must have understood these points. First one, statutory, and second, under the judicial interpretations. Coming to the second point, sub-point, under this judicial interpretation, service agreements. An agreement of service between the employer and the employee by which an employee binds himself during the terms of the agreement not to take up any service with any other employer or is not regarded as a restraint of lawful profession and is perfectly valid. Nowadays, it is happening. Many young people are joining MNCs, and when they join, they will have to fill a bond that they're not going to leave the company before 2 years or before 3 years. So restriction is there, but this restriction is not void, it is valid. But I would like to add to this, the restriction beyond the period of employment or after the termination of the service is not valid. Beyond the period of employment, one can do anything, provided it is legal. And after the service is over, then also, person has the right to take up any job, any lawful job or legal job. So friends, this will be valid. Now, take the examples of doctors. Person is doctor in the government hospital. That doctor cannot run his private practice without the permission of authorities. Similarly, person is CA in the MNCs. Then that he is not allowed to carry on his private practice without informing the authorities. So restrictions are there, but these restrictions are not void, they are valid. So there is a case law, one case law I would like to make a mention, which is Lumley versus Wagner. Miss Wagner agreed to sign at the theatre of Mr. Lumley for 3 months and not to sign elsewhere. It was held in the course of law, she can be restrained from singing elsewhere during the period of 3 months. If during 3 months she goes anywhere, then the owner of the theatre has the right to bring injunction order from the court. Injunction order is the order which restrains, which is always provided by the court to such person, whereby the person will be restrained from giving her performance at anybody's theatre. So restrictions are there, friends, but these restrictions are not void, they are valid. Now, coming to the third sub-point, which is sole selling agreements. An agreement between the manufacturer and a sole selling agent or distributor, whereby manufacturer agrees to sell all his output to the sole selling agent. As per the terms of the agreement, the sole selling agent or the distributor may be restrained from selling the goods of some other manufacturers. So friends, even in this example, which is here, XYZ Limited, Medicine Manufacturing Company, appoints ABC Distributor Limited as sole selling agent and agrees with them that sole selling agent shall not sell the medicines manufactured by other companies. So sole selling agents, they are exclusive agents. They are not allowed to sell the goods of other manufacturers. So here restraints are there, but these restraints are not void, they are valid. So friends, I have answered one question. Agreements in restraint of trade are void. State the exceptions to this rule. So first of all, you will have to write the rule which is contained under section 27, and then you have to write about statutory exceptions and judicial exceptions with all sub-points. And now friends, I'll take up second question. The heading for the second question is wagering agreements. What is wagering agreements? What is the impact of wagering agreements? What amounts to wagering agreement? What does not amount to wagering agreement? And how is the wagering agreement different from contract of insurance? All these headings I am going to take up in this video lecture. The Indian Contract Act does not define the wagering agreement. So the definition of wagering agreement does not find any place under the ICA 1872. But Sir William Anson defines a wager as a promise to give money or money's worth upon determination or ascertainment of an uncertain event. So friends, I'll explain essential features of wagering agreements. There are certain features which become evident from the definition which is given by Sir William Anson. First is promise to pay money or money's worth. Now, there must be promise to pay money or money's worth on the occurrence of uncertain event. So either the money is paid or the payment can be done in kinds. Equal chances of gain or loss to the parties. Each person has the equal chance of gaining or losing, winning or losing. If there is any case where person can win only or can lose only, then that will not be taken as the case of wagering agreement. Friends, even if event is uncertain, the most essential feature of the wagering agreement is promise to pay money or money's worth, which is dependent upon the determination of an uncertain event. Event is not certain, event is uncertain. Nobody knows what is going to happen. The crossword competition is not a wager since it is based upon skills and not uncertain event. India winning the match or the other country winning the match or raining on a particular day or who will win the elections, all these are the examples of wagering agreement. No other interest in the event. Parties do not have any other interest in the event. Their main motive is to win or to lose. No other interest they have in the event. Neither party to have control over the event. Nobody has control over the event. It is not in the hands of anyone to make India win or to make the other country win. I'm not talking about match fixing. So friends, parties do not have control over the event. So these are all examples of wagering agreement. Raining on Independence Day, and then second is regarding Indian cricket team winning the Gold Cup, and the third is elections about MCB. Now, before I proceed further, I would like to add to this that when we talk about uncertain event, it is not necessary that event must be the future event. It may be the past event also. That is, provided the results of the past event are not known to the parties. Third example is regarding this, which is regarding MCD elections. So friends, I hope you all must have understood all the points. If you have any doubt, do write in the comment section. I will definitely reply. And now friends, I'll take up the heading Effects of Wagering Agreements. Section 30 provides that wagering agreements are void and they cannot be enforced between the immediate parties. So they are void, they are not valid, they are void. The winner of a bet cannot sue to recover the amount deposited by the loser with the stakeholder. So what happens? Money is deposited with the stakeholder. If the person loses, then in that case, the money has to be paid by the stakeholder to the loser. But if the stakeholder has paid the money to the loser, then in that case, the money to the winner, the loser cannot recover the money from the stakeholder. But if say India has won the match and the A and B, they have entered into the betting agreement that if India wins the match, A will pay 1,000 to B. If India loses the match, B will pay 1,000 to A. A has deposited this money with C, stakeholder. And let us presume India has won the match. So as per agreement, A has to pay 1,000 rupees to B. So money is with the stakeholder C. If C has paid the money to B, then A cannot recover this money from C. But if C has not paid the money to B, then A can recover, loser can recover this money from the stakeholder. So friends, the next effect of wagering agreement is that Supreme Court has provided in one of the case laws that wager is void and unenforceable. It is not forbidden by law. Since a wager is not unlawful, the transactions collateral to main transactions are enforceable. So friends, here say I would like to continue with the same example. A has to pay 1000 rupees to B provided India wins the match. Let us presume India has won the match. A has to pay 1000 to B. Now A borrows this money from C. So there are two transactions. One is between A and B and second is between A and C. So the agreement between A and B is void, but the agreement between A and C will be valid. That is collateral transaction. So collateral transactions in case of wagering agreements are always void. The collateral transactions are always valid, but the main transaction is void. But in the state of Gujarat and Maharashtra, the wagering agreements have been declared to be illegal. With the result, the collateral transactions, they are also regarded as illegal. They also become tainted with illegality. The same provisions we have in case of under England law also. And now friends, I'll take up certain transactions similar to wager. If wagering is void, then these transactions are similar to wager. They will also be regarded as void. First is a lottery transaction. Lottery is a game of chance and not of skill or knowledge. You all know, friends. When the prime motive of participant is gambling, the transaction amounts to a wager. The only effect of such sanction is, even if the lottery is sanctioned by the government, the only effect of such sanction is that person responsible for running the lottery will not be punished under the Indian Penal Code. Lotteries are illegal, and even collateral transactions to it are tainted with illegality under Section 294A of Indian Penal Code. Second is crossword puzzles and competitions. Even crossword puzzles, in which prizes depend upon the correspondence of the competitor's solution with a previously prepared solution, kept with the editor of a newspaper. It is a lottery and therefore is a wagering transaction. Now, crossword puzzles, picture competitions, athletic competitions, where prizes are awarded on the basis of skill and intelligence, are the games of skill, and hence such competitions are valid. If it is dependent upon the previous, if the solution which is given by the participant corresponds with the solution given, which is available with the editor, then in that case, that will be of wagering nature. But if it is dependent upon the intelligence of the person or skill of the person, then that will not amount to wager. That will be valid. So according to Prize Competition Act 1955, prize competitions in games of skill are not wagers, provided the prize money does not exceed rupees 1,000. Next is the speculative transactions. Speculative transactions, an agreement or a share market transaction where parties intend to settle the difference only. The market price of certain goods or shares on a specified day is a gambling and hence void. So friends, whether when we talk about commercial goods or we talk about share market shares, if only the difference is received or paid for, depending upon the inflation or deflation, then this is known as speculative transaction. And speculative transaction is always a wager. Next is horse race competition, horse race transaction. Even horse race transaction where the price payable to the bet winner is less than 500, it is a wager. Less than 500 is a wager, but more than 500 is not wager. So why less than 500 is a wager? This is just to discourage the poor people. The poor people, who cannot afford to have the necessities of life, they should not waste their money by participating in the horse race competitions. A and B enter into the agreement in which A promises to pay 200 provided Chetak wins the horse race competition. This is a wagering transaction. And friends, the amount is also below 500 rupees. And now chit fund. So, but as against this, there are certain transactions which resemble with the wagering transaction, but they are not void. In other words, we can say they are valid. First one is chit fund. Chit fund does not come within the scope of wager. In case of chit fund, a certain number of persons decide to contribute a fixed sum for a specified period, and at the end of the month, the amount so contributed is paid to the lucky winner of the lucky draw. So friends, this chit fund is not void, it is valid. Then commercial transactions or share market transactions. If not only difference is paid or received, but in fact, the goods are sold or they are purchased, or shares are purchased or sold, depending upon the inflationary or deflationary trend in the market, then this will not amount to wager. Games of skill, athletic competition, and all, where the prize money is dependent upon the intelligence of the person or skill of the person, then this will also be valid. And the last one is a contract of insurance. A contract of insurance is a type of contingent contract, conditional contract. If the loss is suffered by the person, then only the insurance company will make up the loss for the insured person. Contingent, conditional contract, and it is valid under the law, and these contracts are different from wagering agreements. So friends, till now, relating to the wagering agreement, I have covered what is wagering agreement, what are the features of wagering agreement, effects of wagering agreement, then what amounts to wager, which transactions amount to wager, which transactions do not amount to wager. And then now I'm going to take up how is the wagering agreement different from contract of insurance. Difference is in the T form. The very first is meaning. Contract of insurance is a contract to indemnify the loss, to make up the loss, to compensate the loss. But a wagering agreement is a promise to pay money. Money is what? On the happening of uncertain event, which you all know. Then consideration. The crux of insurance contract is the mutual consideration, premium and compensation amount. There is no consideration between the parties. It is just a gambling transaction. Insurable interest. When we talk about contract of insurance, parties do have insurable interest in the life or property. Depending upon this, are we talking about life insurance or we are talking about other insurances? But in case of contract of wagering agreement, there is no property which need to be insured. Then contract of indemnity. Except life insurance, the contract of insurance indemnifies the insured person against loss. Loser has to pay the fixed amount on the happening of an uncertain event in case of wagering agreement. Enforceability. Contract of insurance is always enforceable. It is always valid. If loss is suffered by the insured person, then the company has to pay that amount to the insured person. And when we talk about wagering agreement is void and it is unenforceable agreement. Then premium. When we talk about calculation of premium, is based in case of insurance. It is always based on scientific and actuarial calculation of risk. But there are no logical calculations which are required in case of wagering agreement. Now, contract of insurance, they are always beneficial for the society, but a wagering agreement is not regarded as for the public welfare. They are against the public welfare. So friends, this was all about this wagering agreement. I hope you must have understood the content. We like the content. Do like the content. Do like my videos. Do subscribe to my channel, and do press on the bell icon so that you can get notifications of my subsequent videos. Keep smiling and stay blessed always. We'll meet very soon. Okay, friends. Bye-bye.